5 seconds to go. Start. It was his specific case that during the relevant time he was working at ICICI Bank, Khalilabad branch, Gorakhpur, and his mother was also staying with him. The branch manager has endorsed his presence in the branch, showing in time at 9:49 am and out time at 6:25 pm. Even in the statement of second respondent recorded by the police and also in the final report filed under section 173(2) of CRPC, except omnibus and vague allegations, there is no specific allegation against the appellants to show their involvement for the offences alleged. This court time and again has noticed making the family members of husband as accused by making casual reference to them in matrimonial disputes. Learned senior counsel for the appellants in support of her case placed reliance on the judgment of this court in the case of Geeta Mehrotra and another versus State of Uttar Pradesh and another. In the aforesaid case, this court in identical circumstances has quashed the proceedings by observing that family members of husband were shown as accused by making casual reference to them. In the very same judgment, it is held that a large number of family members are shown in the FIR by casually mentioning their names, and the contents do not disclose their active involvement. As such, taking cognizance of the matter against them was not justified. It is further held that taking cognizance in such type of cases results in abuse of judicial process. Paras 18 and 25 of the said judgment, which are relevant for the purpose of this case, read as under. From a perusal of the complaint filed by the second respondent and the final report filed by the police under section 173(2) of CRPC, we are of the view that the aforesaid judgment fully supports the case of the appellants. Even in the counter affidavits filed on behalf of respondent numbers 1 and 2, it is not disputed that the first appellant was working in ICICI Bank at Khalilabad branch, but merely stated that there was a possibility to reach Gorakhpur by 8 pm, though there is an allegation of causing injuries. There are no other external injuries noticed in the post-mortem certificate except the single ante-mortem injury, that is ligature mark around the neck, and the cause of death is shown as asphyxia. Having regard to the case of the appellants and the material placed on record, we are of the considered view that except vague and bold allegations against the appellants, there are no specific allegations disclosing the involvement of the appellants to prosecute them for the offences alleged. In view of the judgment of this court in the case of Geeta Mehrotra and another, which squarely applies to the case of the appellants, as are of the view that it is a fit case to quash the proceedings. For the aforesaid reasons, this appeal is allowed and the impugned order dated 10th December 2018 passed in application of 2018 by the High Court is set aside. Consequently, the charge sheet number 1 dated 12th October 2018 filed in FIR number 136 of 2018 on the file of PS Kotwali, District Gorakhpur for the offences under sections 498A, 323, 504, 506, 304B of IPC and sections 3 and 4 of the DP Act and the consequential order dated 22nd October 2018 passed by the Chief Judicial Magistrate Gorakhpur is hereby quashed. Stop.